Assault in the second degree, domestic violence in Washington state. What is that charge? How do we defend it? What do we do about it? Have you been charged with that? Is someone you know or love been arrested about that and you're looking for help or just information? If so, this is the video for you, so stay tuned. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes for more than 20 years. And a charge we often get is assault in the second degree domestic violence. It's more and more common all the time. That's because of the nature of the charge, how it's defined, and how certain prosecutors handle that type of charge and use it as leverage. So I'm putting out these videos to educate the public. So if you find these useful, please like and please subscribe. More people will get the information they need. Now I'm just going to jump right into it. So what is assault in the second degree? I'm not going to get into the exact definition, though I'm going to put a link to the definition in the description. But think about it this way. It's an allegation where a defendant is either assaulted somebody which caused more serious injury than normal, typically either stitches or a broken bone, right? Or more commonly, what we see it all the time is the claim of strangulation or suffocation. And that is the most common assault in the second degree type charge we see, because, you know, there's a normal fight going on and you get hands near the neck. Well, now there's a claim of choking, or the police want to find choking, and now they can leverage a felony charge, assault in the second degree, over a defendant, as opposed to a regular old non-felony assault in the fourth degree charge. Assault in the fourth degree is any unwanted touching, but if the police officers can find a claim of strangulation or suffocation, then all of a sudden there's a lot more leverage on the defendant. They can raise it to assault in the second degree, which is a major felony and called a strike offense. 3 of those and you get life in prison, okay? This is why we see so many of these cases lately. So how does the case normally happen? There's a dispute between people, usually dating people, married people, roommates. Someone calls the police and the police show up. Either there's a serious injury or somehow strangulation or suffocation claims, and now the defendant will get arrested. So what happens once the defendant is arrested on an assault 2 DV charge? Is the defendant instantly charged with a crime? And the answer is no. The defendant is not charged with a crime yet. A police officer can arrest for investigation of a felony, but cannot charge someone with a felony, and that's a big difference. And we have a lot of videos on that subject here on our channel about what happens if you're arrested for a felony, that type of stuff. But basically, if you get arrested for assault 2 DV, whoever gets arrested is going to have a court hearing where the court reads a short version of the report and determines whether or not there was reason to arrest, and then sets a bail for where you have to pay money to get out of jail while there's a charging decision being made, or releases the defendant with certain conditions without posting bail. Typically, regardless of the bail issue, there'll be conditions of not having contact with the alleged victim, don't commit crimes, stuff like that. So under our court rules in Washington state, basically a court can only maintain conditions on an arrested but uncharged defendant for up to 3 court days. And therefore, a prosecutor, who's the only one who can charge a crime that's a felony, and the prosecutor is an attorney who works for the prosecutor's office, they have to make a decision within 3 court days. Am I going to rush file to maintain those conditions on the defendant, file the assault 2 charge right away, or am I going to let more time pass and let those conditions expire and take a longer period of time of thinking whether or not I have a viable case? Do I have a case I can actually prove that I should charge, or as a felony, or should I charge it as something lesser than that? And so if they don't rush file in 3 court days for felonies, most felonies a prosecutor has 3 years to make a decision under the statute of limitations, and 2 years for non-felonies for most of them. So that's where we're at right now in the process, right? We've had an arrest, and now we're determining is the prosecutor going to rush file or not. So what do we need to think about then? Well, then we have to think about, can we get the defendant out of jail? If there's a bail that's been set by the court, it's usually a good idea to post that bail, depending on the county you're in. But if you post the bail, there's less reason for the prosecutor to rush file the charge to keep the defendant in jail, okay? if they're sitting in the jail, there's more reason for the prosecutor to say, well, I can protect the public by filing this more quickly. Okay, and so there's strategy involved in sort of what people on the outside can do to help the defendant, because that's what we're talking about here, to try to improve the chances of a better outcome, right? Improve the chances for a better outcome for the defendant. So let's talk about the difference in the counties that I see. The two major counties that we serve, although we serve probably 10 counties, but the two major ones we see are King County and Snohomish County. Okay, and King County is Seattle, and Snohomish County is Everett, that type of stuff. So what we see as far as the culture of behavior of the prosecutor's offices, in Snohomish County, we see very few cases rush filed. Snohomish County tends to have the culture of they want to make sure their case is more provable before they file it, right? And while I'm not running that office, I'm just surmising the reasons why, but it makes some sense. That they want to listen to the input of the victim, the alleged victim. They may not agree they were choked. They may believe that that different things happened, and the prosecutor should hopefully take into account at a calmer time wishes of the alleged victim, because in the heat of the moment, sometimes things aren't always accurately reported. So in those cases, typically in Snohomish County, we're not going to see a rush file. And it could take 3 to 6 months on average for a prosecutor to decide what to do. So you still need an attorney right away in that case, but it's just something different to expect. In King County, on the other hand, the same case, we almost always see that type of charge rush filed. That if someone's arrested, it's going to get filed within the 3 court days. And every case is different. Not all of them do, but a much higher percentage that we see in our practice, and we've been doing this for a long time, are rush filed in King County. And so how does that change the equation? Well, it changes the equation in that there's going to be less time to affect things. There's almost going to be no time to affect a charging decision, and an attorney is needed even more quickly to try to decide what to do. So if a case is rush filed against a defendant, typically in King County, it's going to be filed out of warrant. Which means even if the judge let you out without bail, if a prosecutor files a charge in 3 days, there may be a warrant put out for the defendant that the defendant doesn't even know about. And so once the case is filed, there's usually a court date in 2 weeks on average. So if you've been arrested or somebody has, make sure to reach out to an attorney, because there's a lot of invisible things behind the scenes that are going on that only very experienced counsel can figure out, only people that have experience in that court. And that's why it is typically important to have an attorney who goes to that court somewhat frequently. So that's how the arrest and charging decision happens for assault in the second degree. So that was a long step 1 here, but moving on to step 2 is what to do about it. How to defend an assault in the second degree charge. What are the steps to take to try to get a good result in that case? Well, typically in our office, we're going to follow sort of a 3-step process. One is we don't want to negotiate too early in the case. We want to let some time pass. We want to investigate. We want to see what's in the report. We want to see any body cams that exist more often by police officers. We want to listen to input from the alleged victim. What actually happened from their point of view? What do they want to see happen? We're allowed to talk to witnesses, and it's important that we do talk to the people involved to find out what their wishes are. The second thing we typically do is we're going to have the client do something. If you got into a situation where you got arrested, there's probably some stuff that, it may not be totally your fault. There's some stuff you may need to work on. We might have you do some anger management classes. There's some domestic violence MRT classes. We might have you do some alcohol or drug classes if that was involved. And we're also going to do those things to try to help with the no contact order potentially going away more quickly if that's what the alleged victim wants. And the more you do, then the more likely the court is to listen to the alleged victim's witnesses. Then finally, 3, once the case has been around long enough and you've done enough, then we're going to try to negotiate with the prosecutor. We're going to show your lack of any history. We're going to talk about what problems exist with the case, and most importantly, we're going to show what you've been doing since the case, so the prosecutor's more willing to hear about those problems, right? A prosecutor is a hard job. Everybody wants something from them, right? Let my client go because they're innocent. Let my client go because your officer's bad. Let my client go because of all the great stuff my client's done. Let my client go, it's the first time they had a problem. they can get really, really tired of it, right? I was a prosecutor for 7 years, and I was so tired of negotiating. At one point, I just wouldn't do it, and let other people in my office do it. It's important that sort of everything lines up just right, so the human being, the prosecutor, is more able to, slow down and take the time they need to see the big picture and what a reasonable result in the case is. So what are reasonable results? Well, your best possible result would be a total dismissal, right? A domestic violence, assault and second degree charge being dismissed totally is hard to do. It depends on the facts, right? Because usually there's some unwanted touching. We could say self-defense. That would be a way to get it totally dismissed, that the only reason there was any touching was you defending yourself. We could say that you can't prove the case, prosecutor. Maybe the victim's gone or disappeared or not cooperative, and there's no other evidence because there's no admissions. So there are some ways to get a DV Assault 2 case dismissed. There's also trying to get it reduced, right? DV Assault 2 is a felony. Loss of firearm rights, loss of voting rights. You're not going to be able to get it vacated from your record ever in this state, the way the law is right now. If it gets reduced to a misdemeanor, which like DV Assault 4, something like that, you are going to be able to get it vacated eventually. It's not going to be a felony. You might still have a loss of firearm rights, but you'll be able to get those back. And oftentimes we're going to keep you out of jail on a reduction. So those are things that we want to try to negotiate for. So what are some things to worry about in an Assault 2 charge if the case isn't going well? Well, you got to worry about that it's a strike offense. Hopefully you don't have a prior history where you're going to be, third strike and you're out type stuff. So talk to your attorney about that. Secondly, you have to worry about what the penalties are, right? So it's a major felony, right? So you could be sent to prison for years depending on your type of record. And typically speaking, when you get sent to prison, you're not getting a work release, you're not getting out. It's not going to be a very good situation. So you have to be really careful when defending Assault 2 charges, because a loss usually will equal jail time. So finally, if you're facing an Assault 2 charge, what can you do to help yourself? Well, the first thing you can do is not panic. Most of these will turn out positively if you have good counsel and you hang in there. So don't panic. The second thing you can do is follow your attorney's instructions, right? Do what they tell you to do. If they want you to do classes, do classes. If they want you to write down everything that happened and give it to your attorney, do that. If they want you to talk to some witnesses that to say, hey, are you willing to talk to the attorney? Try to get your witnesses to talk to your attorney, because sometimes people don't want to cooperate, right? So, do what the attorney tells you to do. And finally, the third thing that you want to do is make sure you get good quality legal counsel. Talk to several attorneys before you make a hiring decision. Listen to how they make you feel, and realize that highly rated attorneys are all going to get a similar result, but you want to try to get the right attorney that makes you feel okay and makes it so you can sleep at night as you go through the case, because usually how you're going to suffer the most in the case is how you feel while it's going on for 6 months to a year, because hopefully we're going to have a good outcome. So if you find this video useful, please like and please subscribe. And if you find yourself in this situation, feel free to give my office a call. My office has been defending these type of charges for more than 20 years. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.